should you pass away without a will in place? We all read about intestate succession. What does that mean?
Or if a person should pass away without a written will in place, that will mean that the Intestate Succession Act will take place and will take precedent. It can be highly emotional because what happens is there's a formula in terms of the Act that states who gets what and who gets to inherit what and what do you need to bequeath what estate to. Meaning that, for example, in that formula, it takes children into consideration, but as well as parents, sibling, and all of that. So if you may be a person and you don't have a valid will in place and you do pass away without a will, we do advise people just please get a will in place. It's an enormous amount of estates that's currently being reported to the Master's Office where, intestate succession actually needs to take precedent, and it can be highly problematic. We see the type of fights coming in through the doors where people want to try and dispute it, and unfortunately the law is the law. So as long as you have a will, the laws are very clear on testator's freedom. You can give whatever you want, however you want, to whoever you want, but as long as it is in writing in terms of the will and in accordance with your marital regime. And if that is not in place or in writing, you may have problems upon your passing.